Hi, this is Brian Dolan with the law firm Pepper Hamilton. Thank you for joining us for our latest podcast. For over 50 years, states have been vexed by one question when it comes to sales taxes. Under what circumstances can a vendor be required to collect sales taxes on sales it makes to consumers within the state's borders? The issue rose to prominence as mail order and catalog sales became more prevalent during the last century, culminating in the Supreme Court's 1992 decision in Quill v. North Dakota that mandated that vendors have some degree of physical presence in the state before a state can impose a sales tax collection and remittance obligation on the vendor. Subsequent to the Quill decision, the very nature of the retail economy changed. People who were shopping locally at bricks and mortar retailers in their hometowns now were able to purchase goods from internet vendors who did not have a physical presence in the state and therefore did not collect sales tax. Today we're going to talk with Lance Jacobs of Pepper Hamilton's Tax Group about a Supreme Court case that revisited the issue in Quill. When can a state require a vendor to collect sales tax based upon a recent South Dakota law? So Lance, tell us about the state of U.S. sales tax law leading up to this case.
Sure. Thanks for having me, Brian. So the history of this issue in litigation goes back a long time, and it's kind of related to the concept of jurisdiction under the Due Process Clause. Although when we're talking about sales tax, the concept of jurisdiction is really referred to as nexus, and it's a Commerce Clause concept rather than a Due Process Clause concept. Modern nexus jurisprudence arose probably about 50 years ago when the Supreme Court decided a case involving National Bellis Hess, which was at that time one of the big five catalog retailers. It was akin to Sears and Roebuck, the catalog that Sears had. The litigation involved the state of Illinois. National Bellis Hess was based in Kansas City and mailed catalogs to customers in Illinois. Illinois residents would place their orders either via the telephone or by mail, and the orders were shipped typically via U.S. mail or common carrier to these Illinois residents. National Bellis Hess had no physical presence in Illinois, but the state nonetheless asserted that National Bellis Hess had to collect and remit sales tax in Illinois. The Supreme Court ultimately declined to require National Bellis Hess to collect sales tax, saying that vendors could not be required to collect such taxes unless they had substantial physical presence in the state. Quill was decided 25 years later. Different company, different products, office products this time, different state at issue, North Dakota, but otherwise the same fact pattern. Again, the Supreme Court declined to require vendors to collect and remit sales taxes without some sort of bright-line physical presence in the state.
So when Quill was decided, how did the states react?
So it's a little misleading to think about it as a reaction to Quill. It was really a reaction to the technological advances of the year 1994. I'm referring, of course, to the beginning of the rise of e-commerce with the founding of companies like Amazon. While mail order grew during the time from National Bellis Hess to Quill, at the risk of stating the obvious, e-commerce completely changed the way that business was done in this country. More or less at the touch of a button, it was easy for a consumer to buy whatever they wished from a vendor online. From the vendor's perspective, it could sit on a perch in Washington State or wherever and sell to customers worldwide without ever setting foot in the customer's state, local, or international taxing jurisdiction. This was obviously vexing to the states and resulted in a significant loss of sales tax revenue. When I grew up and I went to my local mom-and-pop bookstore to buy a book, the state got its percentage of the sale via sales tax. Now, if I were to buy the book online, I'm just paying for the price of the book, shipping possibly, and the state doesn't get the same sales tax revenue unless the vendor has physical presence, and therefore no responsibility to collect it. There's a word we had here about use tax. Use tax is a complementary tax to sales tax. And in the example I just gave, even though the vendor didn't collect sales tax on the sale of the book to me, I'm theoretically supposed to self-assess and report the use tax, which mathematically is the same as the sales tax, to the state on my purchase of the book. Obviously, given the self-assessed nature of the tax, compliance is low, enforcement is really hard, especially among individual consumers as opposed to businesses. Probably the most famous example of use tax that people think of when they think of use tax involves the former CEO of Tyco, Dennis Kozlowski, who was actually prosecuted by New York State for not paying use tax on paintings, be they Monets, Renoirs, whatever they were, high-end items that he bought and had shipped to his property in Vermont and then transported to his house in New York City. So he was technically supposed to self-assess and remit use tax on those paintings, and he never did so, and he ended up in prison as a result. Anyway, that's an interesting aside and shows the complementary nature of the use tax obligation. Given the complex nature of use tax and the self-assessed nature of it, states would obviously prefer to have a vendor collect sales tax rather than trying to collect use tax from the consumer. So states then tried to bend over backwards to try and find physical presence on behalf of vendors. Truth be told, this effort started before Quill, where states were trying to find physical presence for mail order companies by virtue of their relationship with affiliated bricks and mortar retailers. So the jurisprudence is littered with a lot of cases that involve Bloomingdale's by mail and SFA Folio, which were affiliated with Bloomingdale's and Saks Fifth Avenue, respectively. It ramped up, however, and states started to look at unrelated third parties as a means of creating nexus after e-commerce became a significant component of retail in this country. And the leader among states, as is often the case in many state tax cases, is the state where I was born, New York State. New York enacted a law that said if a company had annual sales exceeding $10,000 due to that company's relationship with affiliates, and here, since this is an audio podcast, please be advised that I'm using air quotes around the word affiliates, it would be required to collect sales tax on all sales to the state, not just those through the affiliates. Affiliates for this purpose was defined as a third party who placed advertising for a company, typically on its website, and was compensated on a commission basis rather than on a flat rate for the advertising for sales made by the first company as a result of someone clicking on the link on the third party's website. This nexus concept became loosely known as click-through nexus, and Brian, you'll be surprised to learn that the law was colloquially referred to as the Amazon law. So Amazon and Overstock and a couple of other internet retailers challenged the provisions of this law all the way up through the system, and they lost. The Supreme Court denied certiorari to hear the case, so the law stood, and this was seen as the Supreme Court's de facto blessing of the Amazon law, and other states followed suit. Another way that states reacted was led by Colorado, which basically said, okay, internet vendor, you don't want to collect sales tax for us. We can't make you, but we can require you to comply with a set of onerous reporting requirements. There was a long and tortured litigation history that's irrelevant to this discussion, but ultimately the 10th Circuit agreed with Colorado and upheld the reporting requirements. So as of July 1st, 2017, non-collecting retailers must begin providing a notice of possible use tax obligations at the time of the transaction to customers in Colorado. They also must provide an annual statement to the customer by January 31st, 2018 for all purchases made after July 1st, 2017, and by March 1st, 2018 must provide the required customer information report to the Department of Revenue for purchases after July 1st, 2017. It's a lot of words, but ultimately vendors who don't have a responsibility to collect sales tax in Colorado must nonetheless report both to the consumer and to Colorado who the consumers are and what they've purchased, and let the consumers know that they have a use tax obligation and that they should fulfill that obligation.
Now, can you tell our listeners about the South Dakota law at issue in South Dakota v. Wayfair?
Sure. So the South Dakota law requires any seller that does not have a physical presence in the state to collect and remit sales tax if, during the previous or current calendar year, the seller's gross revenue from sales of tangible personal property and any products transferred electronically or services delivered into South Dakota exceeds $100,000, or the seller sold tangible personal property, any product transferred electronically, or services for delivery into South Dakota in 200 or more separate transactions. It's worth noting that retroactive taxes could theoretically be in play. In other words, states could take the position that this has been the law for a long time and could try to assess sales taxes going back in time, though a significant number of states have pledged that they won't attempt to apply a decision in favor of South Dakota retroactively, though it is worth noting that not all have agreed to do that.
So let's talk about the arguments. Start with South Dakota. How are they arguing this?
The strength of South Dakota's argument, it seems to me, is twofold. The principal argument is the loss of revenue. In other words, people are buying stuff from internet retailers, and they're not paying sales tax at the point of sale, and they're not really paying use tax. They're not self-assessing or remitting use tax to the state. It's unclear how significant the loss of revenue is, and Wayfair has a counter-argument to that, which we'll discuss in a second. The second, and I think this is their stronger argument, is what I like to think of as the Main Street fairness factor. Say you're a novelty t-shirt vendor with a bricks-and-mortar store in the Black Hills of South Dakota. You would be collecting sales tax at the point of sale. If, however, a resident can buy the same t-shirt at the same price without paying sales tax and possibly without paying shipping online, well, that's a huge advantage for the internet vendor. And it's this fundamental unfairness that they want to address.
And how about Wayfair?
Well, Wayfair, as you might expect, has its own spin on the lost revenue angle. Counsel for Wayfair cited a study from the General Accounting Office that said that 80 or 90 of the largest internet retailers are collecting and remitting sales taxes in most states. And indeed, Chief Justice Roberts seemed to agree with this concept, noting that most online retailers now have physical presence in most states, and that the Quill physical presence problem may have peaked, and the pendulum might be swinging the other way. Additionally, Wayfair noted that the average internet sale is $84 a sale. So 200 sales of $84 each comes to about a little less than $20,000. So if you're a vendor who's just at that threshold, the costs of administering, collecting sales taxes, defending audits, and the like would be a relatively significant percentage of a $20,000 worth of gross sales. So this could be a barrier to entry for a lot of smaller companies. Wayfair also argues that the states already have a mechanism for collecting any lost revenue, enforcing its own use tax laws to make customers remit the use tax on their purchases. The fact that these laws are difficult to enforce isn't really the fault of the online vendors. Finally, this case is really being decided under the Dormant Commerce Clause doctrine. The Commerce Clause itself grants Congress the authority to regulate commerce between the states. The Dormant Commerce Clause, on the other hand, holds that states cannot pass laws that interfere with interstate commerce. Wayfair's argument is that if South Dakota loses in the Supreme Court, it and the other states can still try to lobby Congress to pass a law allowing the states to do exactly what South Dakota seeks to do here.
Okay, so I'm going to ask you to dust off your crystal ball and give us a prediction, and if you're wrong, I'll edit it out of the podcast, so don't worry. But can you tell our listeners how you see this case being decided?
Sure. So I'm not a big read the tea leaves guy based upon the questions that a particular justice asked or didn't ask, or noting if Justice Alito rubbed his nose when he asked a particular question. So my response here is strictly a reaction to the arguments presented, and not necessarily what will happen. Put differently, this is how Supreme Court Justice Lance Jacobs would decide the case, and we'll find out in a few months if Justice Jacobs would be joining the majority or the minority. If you had asked me before the argument, coming at it strictly as a practitioner, I would have said that the Quill-Bellis House rule was outdated and didn't reflect the conditions in the current economy and needed to be ripped up. After hearing the arguments, though, I'm not so sure. First of all, the argument that Justice Roberts noted, that the pendulum on internet sales may be swinging back the other way as most of the big players are collecting and remitting in most places, so the lost revenue may not be much of a problem, and in fact, it may become less of a problem over time. Secondly, I think a repeal of the Quill holding will unfairly punish smaller businesses selling online. Finally, I think the issue has become somewhat of a game of chicken between the Supreme Court and Congress, since Congress can act to expressly permit what it is that South Dakota seeks. Keep in mind that there's also value in stare decisis, the idea that you should not overturn Supreme Court precedent unless there's a really good reason for doing so. So after reading all of that, as I sit here and think about all the issues, I think the proper fix to the problem, to the extent that it still exists, is congressional action or a broad state uniform legislative solution akin to the Colorado solution. There are so many shades of gray and differing issues to be addressed, it's hard to imagine them being addressed appropriately in the context of a judicial opinion.
Well, this is real interesting. I know I appreciate it, I'm sure our listeners do. Thanks for spending a few minutes with us to go over the case.
Thank you, Brian.
And for our listeners, if you're interested in cases like this, I'd ask you to visit Pepper's tax section of our Insight Center at www.pepperlaw.com, where this podcast is posted, and we'll be on the lookout for the opinion when it comes out in a few months.